nice and good things happen. You're aggressive to cops. You're aggressive here. I mean, the only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and
Pulled over.
fighting in the Uber.
In the Uber, yes, Your Honor. The Uber driver pulled over. The Uber driver stated to officers that the defendant was slapping and punching the complainant, who was his girlfriend, who was the defendant's girlfriend. And the Uber driver had called the security officer on duty to get help with the situation. I'm sorry, Your Honor. It's reading directly.
DVD's here. I don't know if Sebastian's had a chance to even look at it yet.
Actually, stay close to that area, will you? Don't come here. Stay close to that area.
Yeah. Okay, sorry.
So we're just doing PC. All I've heard so far is that they're both highly intoxicated, arguing. He's allegedly punching and slapping in an Uber car. That's all I've heard so far.
So then Uber driver pulled over, called the security officer on duty, but the defendant got out and started walking. The security guard followed him until he got to the beginning of the subdivision. Then officers arrived and observed the defendant on the sidewalk. Officer tried to talk to the defendant. Once the defendant started to tell the officer, quote, "Leave me the fuck alone. You people are a piece of shit, and that's all you'll do is treat people with no respect." The defendant started walking towards the officer, dropped the pill bottles, and kept saying, "Leave me alone, get away from me." Officer asked the defendant what it was that they're trying to hide. Defendant said that that's my marijuana. Defendant was combative, telling the officer to fuck off. Officer made contact with the complainant witness, said they were a party, they both got drunk and started fighting when they got in the Uber. And the complainant witness stated that she did not feel pain. I think that's where we're at.
Do they see any visible injuries, anything of this nature?
Judge, as far as that goes, what's in the DIMS here is that the witness stated that he observed the defendant with enough force that she covered her face, fell to the floor, and that the witness observed the complainant based on her actions to appear to be in pain. Specifically that the punch was of such a force that it caused her to fall to the floor of the vehicle and cover her face after she was punched. I think that's where we're at with that.
Again, Judge, to answer your question, there's no indication that there were any injuries at all, any marks, and as he just read, she said she did not feel pain, she did not want to press charges, and I have an affidavit on prosecution as well that I'm going to be getting to the state.
Yeah, so as far as bodily injury goes, of course, we don't need necessarily direct evidence. Pain can be something that can be inferred based on conduct. We understand that, a punch of a certain amount of force from a witness's perspective.
Did they get any statements from the person who saw the punch to?
Again, that was the Uber driver. And that's what the Uber driver said, that based on what they saw, the punch had enough force that it caused her to fall to the ground, covering her face.
The officer goes to interview the complaining witness, I'm assuming, and doesn't see anything?
I don't see any indication that they saw anything.
And she says, I felt okay. And I do not want to press charges.
Mr. Child, there are people in life when they drink, they're the life of the party, they're fun to be around. And then there are those when they consume alcohol, they turn into aggressive, mean son of a bitch they have no business drinking. If this is you, don't drink. You have but one life. You start racking up cases, you start racking up convictions. All you're doing is you're hurting yourself. Be nice and good things happen. You're aggressive to cops, you're aggressive here. I mean, the only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and over. But don't drink if you're going to be in jail. You know, really, we have enough death and dismemberment in our city now as it is. Don't be on the news. All right, I'm going to find no probable cause.
Thank you, Judge.
All right, Judge, next is page 3, Barber, come on up.
Coming up.
Yeah, yes, I heard.
All right, good morning, Mr. Barber.
Thanks, man.
Sir, you're charged with racing on a highway. You're facing up to a year in jail, and I'm sorry, you're facing up to 180 days in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 13th, 2025, law enforcement officers observed a large group of performance cars gathered at a location and then saw 2 of the vehicles line up side by side and accelerate to approximately 100 miles per hour. Law enforcement officers recorded the events, and another law enforcement officer initiated a traffic stop where they made contact with the defendant, who was the driver of one of the vehicles that had took place in this outpacing contest. Defendant admitted to being in the races and stated that he never got out of his vehicle while he was at the race.
Do we have a co-defendant in this case?
They're checking now, Your Honor.
And number 1, number 2, does he have a license?
I can check, Your Honor. So the co-defendant's not linked in our system. I don't know if they just weren't able to stop that one.
Right.
But I'm running his license now, Your Honor.
Mr. Barber, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to participate in these types of events again. If I find that you do, first thing I will do is I will put you in jail, and the next thing is I will take away your privilege to drive while this case is open. Do you understand?
Yes, sir.
You're not to participate in any street takeovers, racing, donuts, reckless driving, anything of this nature.
Yes, sir.
His license is eligible, Your Honor.
Can I say one thing?
Do not. Don't. Just the only other thing I'm going to caution you is you are not allowed to drive unless you have valid liability insurance in your name as well. If you don't have car insurance in your name, you're not allowed to drive, and that's a bond condition as well. If I find that you do without, I will revoke the bond and put you in jail. You understand?
Yes, sir.
Do you mind filing those conditions?
Doing that right now, Your Honor.
Do you have the ability to hire a lawyer, sir? Okay, we're going to give you time. I will have you go to Victoria, sign a reset. We will have you go into the jury box while we get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Yes, sir.
Please.
This way.
Good morning, Mr. Henderson. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12th, 2025, officers observed a vehicle driving at a high rate of speed, specifically going 46 in a 35 posted zone. On the officer's car radar. Traffic stop was conducted. Defendant was identified by his Texas ID card. Officers observed the odor of alcohol emanating from the defendant's breath. Based on this, standard field sobriety tests were conducted. Following results: 6 of 6 HGN. Officers detained the defendant, placed him in the back of the patrol vehicle. The defendant did not give a full effort during walk and turn on the first attempt, but did score a 5 out of 8 on that attempt and was given a second attempt, which changed his mind once starting, not completing the second attempt. During one leg stand, officers observed 4 full clues. Defendant was read DIC, consistent to a breath test, 0.143 and 0.134 for the returns.
Mr. Henderson, can you run his license, please?
Absolutely, Your Honor.
Mr. Henderson, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. You understand? You will be randomly tested. If you test positive for drugs or alcohol, your bond will be revoked. You will go into custody. No more PR bonds. You understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
So I don't see anything returning your own driver's license.
You don't have a license. You are not allowed to drive, and that is a bond condition of yours as well. You will be signing an affidavit with me today. This is a promise you're going to make to me that you're not going to drive. I don't care what your excuse is. If I find that you drive, it's really not going to go well for you. Do you understand, Mr. Henderson? If you want to drive, go get a license, get insurance, and I will happily take the restriction off. Do you understand? Do you have the ability to hire a lawyer? Can you look to see if he has any prior DWIs, please?
Yeah.
No, I do not. Deputy Miranda's going to give you an application I need to know everything about you to see whether you qualify for a lawyer. We'll have you sign this affidavit and then we'll have you fill it out. So, okay, go for it. Any priors, please?
A lot of extensive out-of-state history, Your Honor, but I'm looking for DWIs.
Miras aquí, ponte aquí, ella va a traducir. Échase para adelante con confianza, por favor.
Buenos días.
You're Mr. Mata
¿Usted es
Rojas.
señor Mata Rojas?
Sí.
Yes.
You were charged with
Se
assault
impuso un
of a
delito
family member.
familiar.
You are facing up
Puede recibir hasta
jail
un
and or
año
a
de
$4,000
cárcel hasta
fine.
$4,000 de multa.
We are going to do
Vamos a
probable
hacer razón
cause. Have the
culpatoria,
right to
tiene
remain
derecho a
silent.
permanecer silencio.
Anything you say
Todo lo que
can or
usted diga lo
against
podemos
you.
usar contra usted.
You have the right to have an attorney
Hecho de-
present. If you cannot afford one will be appointed to you.
Cada uno dice,
Law enforcement
los
officers
oficiales
were dispatched to a
fueron
disturbance.
a la llamada
Upon making
al llegar
scene,
a la cena
they spoke
y
with
se hablaron
the
con
10-year-old daughter of the
la hija
complainant,
de 10 años de la figante,
who stated
que
that her
dijo que su
mom
madre
was hit in the face
le
by her
pegaron
dad.
en la cara por su padre.
The complainant
La
stated
hija
that she was
dijo
struck
que ella
in the head
en la cabeza
at least 3 times
3 veces
with a closed
con un
fist,
puño cerrado.
while also being
Ellos
kicked
también patalearon
on the side of her torso. While this was going on,
mientras que esto estaba
the
ocurriendo.
defendant
La
had barricaded himself
cerrado
in the children's bedroom
en el cuarto de los niños
of the residence.
de la residencia.
Complainant also stated
También dijo de que
that she was dragged by her hair.
le agarraron de su cabello.
The 10-year-old
La
child
niña de 10 años
observed all of this.
observó todo.
The victim, the complainant stated
Exactamente dijo de que
she felt
ella
pain
sintió dolor
during this,
durante
but was unable to provide a number.
y se pudo dar
on a scale of 1 to 10.
numeración a un menos a 10.
Yes, Your Honor.
Estaba involucrado algo, dice así, sí,
10-year-old witness did advise that the
niña de
defendant
10 años
had been
dijo
drinking
de
some
que
kind
había
of
dado, había
alcohol.
bebido un tipo de alcohol.
Mr. Mata Rojas, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail.
Te voy a encarcelar.
I want you to know that I will protect every person in my county at all costs. I don't care who you are. I don't care why you're here, how you're here. If you're not in this country with permission and you go to jail and immigration finds you, they will possibly put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with.
Hasta que se acabe el caso.
Do you
¿Lo
understand?
entiende? Contesta.
Sí.
Yes.
Not to have contact with the complaining witness in this case. You're not to be in possession of weapons, and I don't want you to go within 200 feet of where she lives or where she works.
Judge,
Su señoría,
it seems like the
Parece
CW
que
is
tiene
going
que
to
tener
want to protective order. I've instructed them if they do, we'll have to come to court and you'll have to see and hear from her if you
I
consider
think the
that.
allegations are,
las
you know,
alegaciones son
There might be some self-defense allegations as well.
I get it, but all I know is that at this time, Mr. Mata Rojas, I don't want you to have contact with the complaining witness in this case. I don't care if she comes to you. I don't care if Jesus comes down and says we're having a party and she's there and they want you there. Don't have contact with the complaining witness. Do you
¿Lo
understand?
entiende?
Yes.
Yes.
Judge, if she, after like 30 days, if she wants the protective order removed, would you be open to, if she comes to court?
We'll keep an open mind. I don't know.
Yes, sir.
No sé.
All I want to know is that, number one, he's not using, and number two, that she's protected, and that she feels that she's not in danger.
Absolutely,
Ella no está en peligro.
So, I mean, come back in a while and then we can talk to her and we'll see.
absolutely.
But until that,
Is his appearance waived? I know your rule, but I just wanted to hear from the court.
Mr. Mata, you have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Martinez, and he will tell you if and when you have to come back to court. If Mr. Martinez tells me he can't get a hold of you because you're ducking, dodging phone calls, text messages, or you pick up a new case, I will revoke your bond and put you in jail.
Te voy a encarcelar.
Do you understand?
¿Usted lo entiende?
Yes.
Yes.
So we have a MOAP that has been already issued in this case, right?
Yes,
Yes,
Your
sir.
Honor.
Puesto.
There's a protective order that has been issued in this case. I would get to know it. If you do something to violate this protective order, the state can and probably will file a violation of a protective order. And that is one of the worst misdemeanor cases you can pick up. For now, we'll have you go to Victoria's Center Reset. You will then get with pretrial for your bond conditions, and after that, you'll be free to go. Thanks, Herman. Thanks for being patient.
Okay. Have as well?
All right, Judge, next is page 9. Cummings, come on up.
Good morning, Mr. Cummings. So you're charged with deadly conduct. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 11th, 2025, officers were dispatched to a family disturbance call. Officers arrived and met with the complainant, who was ID'd by her Texas driver's license. Complainant identified the defendant by name and date of birth. The complainant stated that an argument occurred between her and the defendant. The complainant stated the defendant grabbed his handgun and held it in his hand as he became angrier. Complainant left the apartment due to fear. Complainant returned to the apartment and contacted the Harris County Sheriff's Office to report the incident. Officers made contact with the defendant. When officers approached the defendant, he stated, quote, "I'm not talking and I don't want to answer any questions." Defendant began to gather his things and grabbed a handgun and placed it in a fanny pack. Officers drew their guns on the defendant, and the defendant stated, "Are y'all going to shoot me?" Shoot me then. Defendant complied with verbal commands and was detained.
Is the brandishing of a firearm enough for a deadly conduct? Because does he do anything affirmative? I guess.
So, yeah, and I would never a PC hearing, Your Honor. I'd have to do some case law research, but I can see how it's charged is brandishing the handgun, putting the complainant in imminent fear of serious bodily injury. I think the reason it probably wasn't terroristic threats because there was no word said.
Right.
It was just grabbing of the handgun.
Let's do this, Mr. Cummings. I'm going to appoint you a lawyer today so we can figure out, because, we get down and dirty with every case because I want to make sure if I find probable cause, there actually is probable cause. So let's do this. I'm going to appoint you a lawyer today and I'll have him talk to you and then we'll revisit this PC hearing momentarily. Okay? Just take a seat, but don't leave. All right? And we'll have you talk to someone here momentarily. Okay. Good morning, Mr. Martinez. Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12, 2025, officers observed a motor vehicle fail to signal a lane change. Officers also observed the motor vehicle's registration had expired in 2022. There was also unconfirmed insurance. Traffic stop was conducted. Defendant was identified by his Texas ID card. Defendant stated he did not have a driver's license nor proof of financial responsibility. Officers learned the defendant was not an eligible driver due to a license suspension back in February of 2024. Officers learned the defendant had 5 prior convictions for failure to obtain liability insurance on his license. Officers asked the defendant if he was aware of his driver's license was suspended, and he advised he was. However, he did not know how it was suspended, saying he was working on his SR22 and reinstating his driver's license.
Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. I don't care what you have to do in this life. I don't care if there's someone having a heart attack and you have to go save them. There's a burning building and you have to save 50 kittens. I don't care. If you don't have a license and liability insurance, you're not allowed to drive. This is an affidavit that you're going to be signing with me. And if I find that you do, every single time you drive, it's a contemptible action, punishable by up to 6 months in jail and a $500 fine every time you drive. Do you understand? Yes, sir. If you want to drive, go get a license, get liability insurance, and I will be doing backflips. So happy I will be to take this off. But if I find that you do, it's really not going to go well for you. Do you understand this, sir? You have the ability to hire a lawyer. No. I can have you fill an application. I'll take a look to see whether you qualify. Deputy Miranda will give you an application. I'm going to have you come swear to us that you're not going to drive. I'll get you to Victoria Sign a reset, and then we'll have you take a seat. Please.
You're going to file law conditions for it.
Yeah. Good morning, Ms. McKnight. Ma'am, you're charged with 2 cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine. And on the interference case, you're facing up to a year in jail and or a $4,000 fine. I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail and or a $2,000 fine.
I did that, Tony.
First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to
I
you.
get that, Tony.
Let's do probable cause and then we'll.
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, but she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here?" After you broke my window of the vehicle, of my vehicle. Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
And what about the terroristic?
So the terroristic threat, Your Honor, and this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number, threatening to shoot up her home. Complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed that the defendant had been arrested at the same location on April 13th for interference with an emergency call and mischief. She was out on bond for that incident.
Should be given conditions not to go back.
Let me check here.
Ms. McKnight, I'm going to find that there's probable cause to go forward with the case. I don't want you to have contact with this person.
It's not for them. I'm praying about that person.
I don't want you to have contact with this person. Do you understand? Are you sure? You understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail. Do you understand?
Yes, sir. I have evidence for all that.
And I'm going to give you a lawyer today. I know that there's two sides of the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with us?
I don't want you to go to his house.
No, I'm talking about, do I have to come to court so I get in contact with her because we have a child?
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well. You need to understand that if I revoke your bond in these cases and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand?
Yeah.
Okay. Deputy Miranda, do you mind? You know what? Don't even worry about it. I'm going to appoint you a lawyer today. I'm going to have you sign a reset with Victoria, and then we'll have you take a seat in the jury box. I'll find you a lawyer. Don't leave until you sign our bond conditions.
Your Honor,
Okay.
I want to wait for the lawyer to set bond on the new case as well.
Yeah, I guess so.
All right, Judge, next is page 31, O'Neill.
You know what? Was a MOAP issued in these cases?
So it's not a MOAP, Your Honor. Let me check. No MOAP. There was a DOB. One of the conditions was no correcting.
I want to do a MOAP on these cases, Vic, so I don't want to forget.
Okay,
So when we do it. What page?
page 31, top of 30.
Mr. O'Neill. Sir, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. All right.
Good morning, Judge. Just 1 second. Pulling up right now.
Okay.
Sir. I thought I was supposed to have an attorney here today.
Did you hire one?
No, the judge that I talked to said that I could have.
That was for purpose of magistration, but it doesn't carry with you until the end. You don't have a lawyer at this time.
All right, Judge. On April 12th, 2025, officers responded to a family disturbance call in Harris County, Texas. The officer ID'd the complaining witness by their Texas ID card. The complaining witness stated that the defendant threatened to shoot her. The complaining witness ID'd the defendant by his Texas driver's license. The complaining witness stated that she is the defendant's daughter and they all live together in their grandfather's residence. The complaining witness stated that the defendant threw her clothes outside. The complaining witness stated she asked the defendant to go get them. The complaining witness stated that the defendant stated, "I have something else for you," and then took his hand and pointed it at the complaining witness, stating, "I'm going to shoot you." Complaining witness stated that they were in fear due to multiple guns being in the house and the defendant having a violent history. The complaining witness stated she observed the defendant holding a black long gun. The officer detained the defendant. The defendant refused to ID himself, repeatedly stating, "What is going on?" The Miranda rights were read. The defendant denied all allegations and stated his daughter, the complaining witness, was lying. Defendant advised that he hadn't seen the complaining witness all day long because she was at the hospital visiting her mother. The officer inquired about this, and the complaining witness stated that she did not go to the hospital. It was only her grandfather who went. The complaining witness stated that she was home and the defendant did see her and threaten her.
All right, Mr. O'Neill, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you, as a condition of your bond, not to have any contact with this person and not to be in possession of weapons. These are your bond conditions. If you violate these conditions, I will revoke your bond, put you in jail.
Absolutely.
Do you understand?
I don't have.
Just don't say anything at this point. Just don't have any weapons. Don't have contact with this person. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, they will potentially file additional charges against you. Do you understand?
Yes.
Okay.
What about the house? That's where all my stuff is at.
What I'm going to do is I'll appoint me a lawyer today. You can talk to the lawyer about what's going on, but I'm going to do everything in my power to protect everybody in this at all costs. You understand? Okay. So look,
She can go wherever she wants. But I'm just asking.
let's do this. Let me appoint you a lawyer. You can talk to the lawyer and we can go from there. Now is not the appropriate time to go through this.
I've been staying at a shelter.
Okay, hold on.
And
I already have an application. So Vic, do you mind appointing him? I already have an application on file. For now, what I'm gonna have you do is I'm gonna have you sign a reset with Victoria while you take a seat in the juror box while I find you a lawyer. We'll have you talk to this person and we'll go from there.
the reset happened in a few days.
We usually do like a month.
What?
I'm gonna have you talk to a lawyer today.
All right, Judge, next is page 31.
Can you find no
Please
contact and no
come on
weapons,
up.
please? And no weapons here. What page did you?
31.
Okay. Good morning, Ms. Ortiz. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge, I missed the last name on this defendant. No problem.
Ortiz. Yeah.
All right, thank you, Your Honor. On April 13th, 2025, officer was dispatched to a motor vehicle accident in Harris County, Texas. The officers arrived on the scene and they met with Houston Fire Department, who stated that they observed the defendant to be passed out behind the wheel of the motor vehicle with the engine on. The witness from Houston Fire Department stated that they put the vehicle in park and took the keys out of the ignition. The officers detained the defendant and the defendant was transported to a parking lot. The defendant agreed to perform standard field sobriety tests. The defendant had a 6 out of 6 on the HGN, a 4 out of 8 on the walk and turn, and a 2 out of 4 on the one leg stand. The DIC was read and the defendant consented to a breath test. And the defendant's results of the breath test were .086 and .087.
Did you say there was an accident?
It says that, yes, sir. Yes, Your Honor. Officers were dispatched to a motor vehicle accident in Harris County,
Did they
Texas.
smell alcohol? Did they see bloodshot eyes? Did they have an odor of anything before they started doing all the tests? Are you losing?
So, Your Honor, I am in the DIMS. It does not say. Yeah, I know. In the DIMS, it does not say. I am checking the office report. I know. I know you're your feelings on that, Your Honor?
Mr. Ortiz, if you watch the news every single day, we have someone dying from a DWI in our county. It's not cool. If you want to go get lit, fantastic. Take a freaking Uber. $40 and one button on your phone. Anywhere you want to go, man. I'm going to find no probable cause in this case. Just be careful. All right? Please. Good morning, Mr. Schaefer. Sir, you're charged with aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
Thank you, Judge. The officer made contact with the loss prevention officer of O'Reilly's Auto Parts, who stated that he received an anonymous online tip about a possible theft regarding one of the employees from the 3498 FM 528 location. That's an address. The tip stated that the defendant had made 2 fraudulent returns and kept the money from them. The first return was back on August 2nd, 2024 for $316.50 for three brake rotors. The complaining witness was able to contact the customer and they advised they did not return the rotors. The other return was on January 16, 2025 for $179. The complaining witness contacted that customer and they also advised that they did not return the product. The total of the 2 returns was $495.50. The defendant admitted to the theft in a written statement. Complaining witness provided the 2 fraudulent receipts and listed on each was Schaefer's unique counter number.
Okay. Mr. Schaefer, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have contact with this O'Reilly. There's not a specific complaining witness, right? So I'll just go into O'Reilly's. You understand?
Yes, sir.
Okay, if I find that you do, if I find that you pick up a new case, it's not going to go well. Do you understand?
Sure.
Do you have the ability to hire a lawyer?
Sure, I can do that.
Okay, we can have you fill out an application. I'll look to see whether you qualify. Deputy Miranda's going to give you an application. I'll have you go to Victoria's Sign and Reset. We'll have you take your seat. We're losing spots.
I want to go with more notes and I'm supposed to.
Okay, well, there's one. Okay, so we'll do all that. We'll have you take a seat there and then let me start. Okay, please.
I'll just call up the next one that should be ready. Theo, come on up.
Okay, we can get Barbara out of here. You want to bring? Barbara, come on up. We'll have you sign.
Barber?
He's THA, so we can get him out. Then,
Have you signed?
What is it?
It's in Glen, I just goes, I'll let you know what it's.
No, I'm saying what's the condition?
I put judgment on here earlier,
Okay.
basic, so I'll take a bar, take over. Well, then,
Oh, that's.
okay, what page?
Page 37, Steele.
All right, good morning, Mr. Steele. Sir, you're charged with evading arrest or detention and theft. On the evading arrest, you're facing up to a year in jail and or a $4,000 fine. On the theft, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, officers were dispatched to a theft in progress call in Harris County, Texas. Officers were given a description of the defendant by an Academy employee. The officers observed the defendant walk out of the store passing all points of sale. The officer attempted to detain the defendant for investigation for the alleged theft. The defendant initially complied with the officer directives. As officer grabbed the defendant's wrists, the defendant began to pull away and evaded through the parking lot. The defendant eventually tired out and officer detained him without incident. The defendant evaded approximately 1,271 feet. The officer confirmed with the reportee that the defendant detained was the one who stole a paintball gun, and officer located the merchandise in the bushes at the Olive Garden where the defendant stated he dumped it. Initially, the defendant denied taking anything from the Academy, but when confronted with being told store cameras caught him in the act, he admitted it and led the officer to where he dumped the paintball gun. The paintball gun was retail priced at the store for $140.
Mr. Steele, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go to any academy. Do you understand? How old are you, sir?
17, sir.
Are you here with anyone today?
Yes, sir. I'm with my sister.
Okay. I'll appoint your lawyer today. All
Yes,
right? Don't get in any more trouble. I don't want to have to put you in jail. You know, if I put your bond at $5,000 to $10,000 and you don't have anyone to put that kind of money up, you'll be stuck like Chuck, man. This is not a good way. All right?
Yes, sir.
So what I'm going to do is I'm going to have bond conditions created for you. Don't get in any more trouble. Don't go to O'Reilly's. What are you doing with yourself? Are you in school? Are you in high school?
Yes, sir. High school. I'm in 10th grade, and I'm trying to find a job right now.
School. That should be your one and only gig. You know, that should be your full-time job because the most you want a paintball gun? Money. You get money with knowledge. You get that with school. That's your full-time job. Do you understand?
Sir.
All right. I'm gonna have you sign a receipt, Victoria. We'll have you just take a seat in the juror box while I find your lawyer. Okay?
Yeah.
Please. We file now going to academies.
Annie Berryhill?
All right, Judge,
Mary Hill.
next is page 13.
Vic, I lost the page. What was it?
Page 13, Garcia.
Good morning, Mr. Garcia. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On June 7th, 2024, officers were dispatched to the complaining witness's residence and met with JV, a minor. The defendant is her older brother. They were having an argument because someone went through his items in his room. The defendant kicked her in her midsection area, causing her to fall on the floor, and struck her with a fist several times. Her younger brother also witnessed this. She felt pain. Defendant left the location before the officers arrived. That concludes.
This is old, huh?
Yes, Judge.
This is from 2024. We're just now getting it? Is it a 2B?
Yes, Judge, it must have been a 2B. We do have another offense from a 2024 date as well, so I'm not sure what brought them in this day.
Mr. Garcia, I'm sending you for a drug and alcohol test. I want to know what, if anything, is in your system now and you're to come back. If you ever take off again, I'm going to make your bond extremely high. No more PR bonds. Do you understand me?
Yes, sir.
You are on bond for a felony as well. I'm will keep my county safe at all costs. You understand?
Yes, sir.
I'm going to appoint your lawyer today, but I'm sending you for a drug test. You must take the test and come back. You understand? All right. I want to send him for a test.
Can you send these charges?
Todo a voz alta.
What page did you say?
Page 23.
Is Victor Lopez?
Yes, sir.
Mr. Lopez, you were charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine.
$2,000.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, in Harris County, Texas, officer was working patrol when he observed a motor vehicle that matched the description of a vehicle that was recently stolen by 3 armed Hispanic males. The officers conducted a traffic stop. The defendants disregarded officers' verbal commands by staying in the vehicle. The driver continued to disregard commands by putting the motor vehicle in drive and operating the motor vehicle through the parking lot. More specifically, the driver drove approximately 20 miles per hour toward Officer Martin and his motor vehicle. The driver continued to evade for approximately 2 miles until the vehicle was damaged such that it could no longer operate. Defendants were detained and a stolen handgun was located under the driver's seat. The complaining witness mentioned that he was robbed at gunpoint by 3 Hispanic males who took his motor vehicle without his consent.
Charge anyone with the aggravated robbery?
We do not, I do not see that here. I'm not sure.
No lo veo aquí, no sé.
Mr. Lopez, I'm going to find that there's sufficient probable cause to go forward with your case. Was this in the middle of the night? Was this in the middle of the night?
Medianoche.
This was
I don't know
Yo
what
no
your
sé
immigration
cuál es su
status is,
estado
Michelle.
migratorio, señor López, pero si no está en este país con
End up going to
permiso
jail.
y termina yendo a la
Immigration
cárcel,
finds
la
you.
inmigración lo
They will
encuentra,
put a detainer
solo
on
uno
you, and
sostiene
you will be
usted
stuck like
se
Chuck
queda
in there.
ahí como el dog hasta que este caso se
I
termine.
want you to
Yo quiero
understand
que
that
usted
I'm
entienda
everything in my
en
power to
todo
protect my
bajo mi
city.
poder para proteger a los ciudadanos
Find
a
that you
todos
become a
costos. Si
danger.
encuentra que usted es
It's
peligro,
really not going to go well.
eso no le va a ir bien, usted lo entiende.
Yes, sir.
I'm sending you now for a drug and alcohol test, and then you're to come right back. If you fail the test, if you fail to come back, I will issue a warrant for your arrest. Do you understand?
Entiende.
You're ordered not to use alcohol, illegal drugs, and I'm putting a monitor on you so I know where you are at all times, and I'm giving you a curfew because I don't want you out in the middle of the night.
Quiero que usted esté por allá afuera.
Tell me you have the co-defendants, please, so we know who they
Dígame que
are.
tienen las buenas de
Cole, the co-defendants, so I know who to tell them not to hang out with.
para que usted pueda decir con quién no debe estar.
We have a couple
Tenemos
of names
un
here
par
in
de
the,
nombres
You can just give
aquí.
me like a cause number, that'd be great.
all right. The cause number is going to be 255
Okay?
956 2.
That's our cause number.
Oh, the cause number for the co-defendant?
Co-defendant.
I don't see it here in the DIMs. I'm pulling up the documents.
Is Bonilla the only co-defendant?
Bonilla and Hernandez, I believe.
Okay, I don't have Hernandez in this case.
Can you give me one of the cause numbers that you have?
Yes, Judge, I have Bonilla, the cause number is 2559576.
Your Honor, I have Hernandez if you would like that as well.
Tiene a Bonilla y Hernández.
Yes,
What
it
is it? What's the other cause number called?
It is 1911823.
Okay. So they got Hernandez on the act of assault with the evading.
Yes, Your Honor.
And the evading.
Robo con agravante.
There's a problem with the Root case. It looks like they put the defendant as the lawyer also as the, and I don't know if that's so they take care of it. But if you want to take a look, they put the defendant as a lawyer. Mr. Luke,
Tengo-
it's 255-9576. Mr. Lopez,
Señor López,
I don't want you hanging
yo
around
no
with the other
quiero que
two
usted esté con
co-defendants in
esos
this
dos
case.
acusados en este caso.
Find that you hang
Si
out with them.
encuentro que está con
Likewise, I will
ellos,
revoke your bond, put you in
igualmente le
jail.
revoco su fianza y lo pongo en la cárcel.
Don't
No,
danger my city. Do you understand?
ciudad, ¿lo entiende?
Yes, sir.
Okay, I want to sign now. Okay, take a seat for me, sir.
Judge, do you want me to appoint or we wait?
Yeah, no, appoint. So, no weapons, no contact with the co-defendants, no using GPS with a curfew, please.
It's Friday and Saturday, but yesterday, went over to my sister's. Out, had a good family day.
Mr. Melendez, I want you to understand something, that you have entered into a plea bargain with the state. I don't have to take this plea bargain, and if I give you anything more than what the plea bargain is, you will be allowed to withdraw your plea, and we can set this case for trial. But did we send him for a test today? Did we send him for a test today?
Drug test?
It was 50 days after when I picked it up.
No, I believe we only did it on day one and you were waiting for him to be clean. But I've already gone through the evidence and got an offer from the state and he decided to accept it.
So we were gonna drop your
I thought like there was 2 months after initial setting and we are now not quite 1 month out. Because I was appointed on 3/28.
Melendez,
18 now.
now, within 2 months, have now 2 convictions on your record. If I take this, why would we keep letting you get convictions on your record to hose yourself? You want to take the easy way out in life. That's not a good way to go, because now You were just making it all the more difficult to get jobs. You want to get funding for anything in this life, not with all these convictions you start racking up. Did you start the framing job or no?
He didn't like answer me the next day, but I've been doing school and I have like every day I do it.
In fairness, I did receive emails showing that he just passed his last course and has now moved on to the next one.
So what course is that?
I went through the mental health. Now I'm in U.S. history.
It's great. You don't want to do a probation to try to keep this off your record?
I don't want to do it no more. I've already been coming for like 5-6 months. I don't want to keep coming and doing it.
When you pick up cases, that's what happens.
I know.
You know, there are half-ass approach, you get a half-ass result. Now you will end up with a second conviction. You don't want a probation. If you do it, right, depending on how well you do it, I take people off early when they do well. All you have to do is stay drug-free and do probably a class or two. If you do that, you don't end up with a conviction on you. It's up to you.
It's a strain. It's a strain on my family. It's a strain on me. Like I have to get my mom to come here every time with me. She has work to do. My dad works.
What you would do is you would report by where you live. You don't come to court anymore if you get on probation. Have you talked to him about a deferred?
I just got the offer from the state. I did not discuss a deferred with him. When I talked to him about the ins and outs of things, he told me he preferred the idea of a time served. So that was what I asked the DA for. I did not even ask for a deferred.
You gotta understand that you're only hurting yourself more and more and more. You now, from now on, are looking at a minimum of 90 days in jail, any new cases that you pick up. If you get buyer's remorse within 30 days, we can talk about it. If you have a change of heart where you would want to prefer to do something else, come back and we can talk. But after 30 days, I lose jurisdiction. This ends up as a conviction on your record for the rest of your life. You can never take it off. You understand? You're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you've worked out is 3 days in jail, credit for the 2 days that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You sure you want to do this? How do you plead to the offense, guilty or not guilty? I'm going to find you guilty. I'll follow your agreement. Good luck to you, Mr. Melendez. Thanks.
Thank you, Judge.
You know that.